Mr. Mayor McCann, you firmly believe, Mayor, that the developer should have to pay an additional $226,000 for this additional phase of development and additional arbor fees every other time that there's an additional fee.
I'd like to correct you. It's not an additional fee.
Okay.
It is their only fee. This is a separate development by a separate developer. It has nothing to do with the past developments on this 45-acre site.
The developer paid $149,000. That is a fact, correct?
I thought it was 133, but they absolutely paid a fee. That is a fact.
But you firmly believe, based on documentation from about 10 years ago, the agreement, the initial agreement with the developer at the time, that only covered a small portion of what they continue to develop today.
All facts, all material witnesses that were a part of those conversations, every piece of documentation we have, all shows that those fees were for the original 6.5 acres of the Blake Apartments here in these 3 lots, and only those 3 lots.
So you put this together for us. So explain to me what we're looking at here.
This is what it was originally called, in this 45-acre lot, roughly, all these numbers are rough, is the original lot that was titled Town Center 2. And originally one developer was going to develop the entire thing. It fell apart, and so it started getting broken up. In 2015, the Blake Apartments was approved. That's these 3 lots. It was approved. There was a tree study done. There were arbor fees paid. A couple of years after that, Dreamfinders built townhomes here, and they had a tree survey done. They paid the city $125,000 in cash and did other tree negotiations. They planted trees in other parts of the city and elsewhere. And now a new half of this big empty lot is going to be developed, and we have a developer that's arguing they shouldn't have to pay the fee because the Blake paid it for them. And that's where the discrepancy comes in. All of our documentation, witnesses that took part in those conversations, says this has nothing to do with the arbor fees that were paid.
Show me that.
So we have a couple of different things. So another drawing. I am concerned that it appears as if there was an omission of fact by the developer, or even a misrepresentation of fact by the developer when they came before the City Commission and the residents of Winter Springs.
On the June 23rd meeting?
Correct.
Okay. And this was shown
this
on
was
the
put
screen
on this same screen just
June
as
23rd.
it is now.
Okay.
And they made these arguments, and one of the things here, this is the original development agreement, and one of the things here that they were arguing, it says west of Michael Blake Boulevard, right? And they were arguing, hey, it might have been on both sides, whatever. Oh, here it is. It says both sides of Michael Blake Boulevard. That's the thing that they were writing on. That was the original. And that was the thing that they were writing on. But then when we went into the final development agreement, right? They'd modified it. And this is 2017.
Okay, I think what you're telling me is this was not the original agreement. You're saying that what was shown this at the 23rd meeting, June 23rd meeting, was copied and pasted?
Exactly, and they omitted key facts in paragraphs that they put in here.
And you can prove that.
And I can show the original documents and show exactly how they remove paragraphs.
Show me.
To benefit their argument.
Okay.
And that is concerning. And look, if it was not intentional, so be it. But it sent the commission down a path of misunderstanding, whether it was intentional or not. They brought in a very highly qualified, very influential attorney that argued their points with precision. She was truly talented. She represented her client well. But I believe the facts show that there are key parts left out of that argument, and I can show you. So what we're talking about basically is the first modification, right? This is the final modification at the end.
Okay.
And what it does is it spells out and deems the original development agreement void. It basically overrides it, and this is the one that matters. It's the last one.
This was the first one written in 2015,
Correct.
and then you're saying this is the section that was copied and pasted during the presentation.
Correct.
from 2017.
Yes.
This agreement. Okay.
Correct. So if we go on, you'll see that they go into a couple of whereas. In other words, back here, they show that, again, we're just talking about from here down, because these are two separate documents from here down, right? We get into, there's a witness, right?
Okay.
Kind of laying out the argument. Then you get a whereas, right? Respect to the development, right? And they keep saying the project, right? And here's the arbor fee, right? And then they say, hey, the recorded development agreement includes the arbor fee, right? In 2017, developer paid that $149,000, right?
Their position,
That's their
developer's position, was intended to cover all current and future.
That's what their
phases.
argument is.
Okay.
But in 2017, if we, again,
This
this
was the
is
second.
actually interesting. No, you know what this is? This is our final argument. Hey, our argument is, this is a request. Our argument is this, hey, we already paid it, so waive the whole thing. But if not, do us a favor, just give us a discount like the Blake got, or that original project, because they got a break on the arbor fee. At least give us that. So they're acknowledging that there's a question about whether or not they hold ground in this argument,
Okay.
right? That's the way I see it.
Okay.
So as you come down here, this is that first modification. Again, 2017.
Okay. This is the actual agreement
This
from
is that
2017.
they recorded in the clerk of courts, finalized, everything.
Okay.
This is a paragraph that they left out. This is one of the paragraphs that they left out, right? Whereas on December 14th of 2015, the City Commission approved the final engineering plan submitted by the developer for the project. This document defines the project and the agreement moving forward.
Where does it define the
Okay.
project?
Right, and it also, well, hold on, let's move on. Next page, look, there's subsequent commission meetings. This is why we had to make changes. They deleted, they dropped all this out. What's really important is this paragraph where it says, foregoing recitals are true and correct and hereby incorporated, right here. And an eventual, right, for the original development agreement, which is the one earlier that they showed.
Okay.
This first modification, this document shall be deemed material part and condition of the final engineering plan. In other words, this document overrides everything.
Okay.
Is what it says. And then it goes through, it talks about the arbor fee for the project.
Okay.
It goes into exactly where how they got there, how they got
Right.
the math done.
But still, what's the definition of the project?
It goes through here, and this is the item from December 14th where we voted on, and this first. So again, going back here, it defines it. December 14th of 2015 defines the project. So let's go to December 14th of 2015. December 14th, 2015.
Okay.
City manager item 505.
Okay.
First modification of development agreement, total 279 units on the east side of Tuscaloosa Road, north of 434, and west of Michael Blake Boulevard.
Not both sides.
Not both sides. And we can pull up that overhead map again and show you that clearly shows the Blake apartments.
So you're saying it was in there from the beginning.
It's been in there from the beginning, and it's in there over and over and over and over again.
But at the June 23rd commission meeting, when you first voted to not charge the additional fee,
I did not, but yes, the commission
not
did.
you, the commission, the majority, this was not shown. This never came up.
What should never have been allowed, frankly, is that the developer came forward and brought in slides and shows and things without providing any of that in advance. That was the first I heard of this. And they brought it in. We should never have allowed them to make an argument and not be told about it in advance. We need the time to research it. And when we did realize that there was a disagreement, we should have tabled the vote and never had the vote. We should have been allowed to do the research. I'll accept some responsibility for that. In hindsight, I should have fought against the vote ever taking place because the facts didn't add up. And they had a very talented attorney making arguments.
Most of the commissioners are new. You pointed that out at the July 17th meeting. They were not around when this was originally crafted back in 2015. How did they not see this? during the June 23rd meeting when they had to decide on this?
We did not
where
have
was
this document. It was in city records. So, right? So as soon as that meeting was over, I started digging out all the paperwork. I started going into city records, right? You can access them, all residents can do so. And I just went online and I started pulling up all of these records and the true documents that they cut and pasted so I could get a full, clear understanding of what was in those agreements. And then when they mentioned December 14th, and I pulled up the documents where it clearly says, again, west of, clearly defines it. And then as we go through this, and again, this is several pages in, again, the intersection of Michael Blake Boulevard, where is it? West of the intersection of Michael Blake Boulevard. Again, west of Michael Blake. Down here again, west of Michael Blake. This is not, the property in question is east of Michael Blake Boulevard.
The one that is developing now.
They keep making the argument that the land east of is covered under this agreement. But if you look at the agreement, it says over and over and over again, it's not included. This lays out the Blake apartments. This is the land that we're talking about now. It's not in this piece of, this is it.
So what do you believe happened at that first meeting on June 23rd? To me, it sounded like commissioners were making a decision based on the limited information they have, trying to interpret what was shown by the developer on the screen about what exactly is the project and what was the project.
I believe that the commission members, all of us are human beings, and they were influenced by the former mayor. They had private meetings 1 to 2 business days prior to this key vote.
And we should say the former mayor is representing the developer now to the commission.
Yes, along with an attorney. And those meetings, although not illegal, should be concerning. It doesn't look good. And they are human beings who, listening to people, they allowed themselves, I believe, to be swayed. The city commission must enter those kinds of conversations with skepticism and really use critical thinking skills when they listen. And when a developer comes to you 1 business day before a key vote like this, you must scrutinize what they say and then listen very carefully, as in this case, when the city staff, the Planning and Zoning Board, and the city's own attorney, and the deputy mayor, who's a material witness, he was involved in the original negotiations, he was on the dais then, all recommend not removing the fee. They need to listen, and they need to listen very carefully. And again, meeting with those developers, they must use a heightened level of skepticism when they listen to these folks.
The former Winter Springs mayor, who is, as we said, representing the developer to the commission, he said during the meeting that he ran out of time, otherwise he would have come to you to try and meet with you privately before the meeting.
I do not meet with developers once they file an application, which is months before a vote. I will not, and it's been the history of the commission over the last 10 years not to do so. We do not. And I would strongly recommend, it is not illegal, let me stress that. It's not illegal to do so. They must notify before they make a vote. They have to say, hey, just so everyone knows, for the record, I met with the developer, say when. I strongly recommend that they do not do that. We've had a long-standing policy of not doing that. The new commission members, I know that they want to help. Their argument, I understand, is that, oh, well, I want to hear both sides and all those things. You have not that close to a key vote. And again, I don't meet with them at all. Once an application is filed with the city, communication is over, send everything in writing, or at minimum, have the city attorney there when you're meeting with them. Have city staff there while you're meeting with them, while they're trying to influence your decision. So this is a learning curve. right? I think they're human beings, and they were influenced. But the facts show we need to turn this vote over.
You knew the facts. You say you knew the facts.
Well, I know the facts now. I'll be honest with you. Look, I didn't know that they were. I never thought that turning over a fee like that would have. We're Tree City USA. We are proud of our tree canopy in Winter Springs. It's our brand. This is who we are. That they would have even considered that or been influenced by a developer. I was taken aback. I was really surprised. I didn't think that was going to happen. But now is our time to correct it. Now that we have all the documentation, now that we have the facts, now that we know that the next development that came through paid $125,000 in cash and that they did a whole lot of other arbor things for the city and for our community, I think it just shows what the facts are. And I'm hoping that the facts kind of shine through and we change that decision.
But during that first meeting on June 23rd, you said you heard the warning from the city attorney. You said you heard the advice from city staff. We heard you. You felt very strongly that you wanted to charge that $227,000 fee.
It's not that I wanted to charge it. I believe in our tree canopy, and I do not believe that we should be showing favoritism from one developer to another. Our residents want to cut down the tree. They have to pay the fee. Why should a well-financed, influential, well-connected developer be waived on a $250,000 fee that everybody else has to pay?
So that you knew at the time of the
Yes.
June 23rd meeting. So as mayor, why didn't you slow this all down? You could have asked them to postpone.
And that was, as I stated earlier, my regret moving forward, and I think I have agreement with the entire commission and the city attorney at this point, is we should have tabled it. We never should have taken the vote that day. As I said earlier, we never should have taken that vote. It didn't occur to me that I had the power to do that at the moment. I didn't see it coming. I never thought that they would then seriously consider it once they did make it. And then I should have considered that, hey, let me just try to stop it before we do something really bad. And so now the city commission, on our next commission meeting, will dive into this in detail and we will make another decision. I fully expect that the developer and their attorney will come back and have an opposing opinion on this. I think when everyone sees the facts, when we really go through it, I think that the city commission, I trust the city commission will make the right move.
Which is rescind the vote?
So the project is going through, but we approved it after we removed the arbor fee. All we're going to do is go back and honor the city staff, the planning and zoning board, the city attorney, and the deputy mayor when they said don't rescind this fee. And that's what we're going to do. We're going to reinstate it, but they will be paying that arbor fee is my hope.
You expect that the commission will reinstate
so.
the fee?
I'm hoping so.
At the risk of a lawsuit from the developer?
Bring it. Discovery, court projects like that are the things you file a suit. Discovery, the documentation that they're going to have to pull up. Remember, the burden is on the applicant. It is not on the city. It is fully on the applicant to prove their case and to come forward with the documentation that can prove their case. Discovery, depositions by all the interested parties and everybody that was involved under oath, bring it. I'd love to do it. I don't think they want that. I don't think it'll go there. But don't threaten us, because that will, I will not shy away from a legal fight.
Mayor, I want to give you a chance to say anything that I didn't ask you.
I guess just as a repeat is that, so we have this initial, there's some, well, I'll tell you what, I will. An email between the city attorney and our community development director days before that vote to approve of the project.
2015.
So
okay.
I guess, yeah, and December 4th versus I think the vote was December 14th, so 10 days before.
Okay.
Where it clearly over and over again, it's talking about the arbor fees, right? How many trees are being removed, how many are being replaced. It talks about the 6.5 acres of the project. 6.5 acres of the project. 6.5 acres of the project. The Blake Apartments is 6.5 acres. It clearly explains what the project is with the other documentation.
That
it's
was
all there.
the first phase, you're saying.
That is that first phase.
A very small part
again,
of what they're developing now.
What I'm trying to say is there's more and more, and I can keep going and going and going with all of this different documentation. There's more and more and more of it. It just shows that they didn't pay for it. And so the city commission, being human beings, made a mistake. And now it's time that we rectify that mistake. They're human beings. It was honest. They were being influenced by a very, charismatic guy who I consider a friend. He might be a little mad at me right now, but I really do. He served his community well. The other thing is just if we go back to the beginning, the only thing is what I'm concerned about is we're not just giving up $230,000 for that first phase. There's another 10 acres that's about to be developed, and we, by fault, will not be able to charge them. They're likely facing $250,000 in arbor fees. And so we're not just waiving $230,000, we're waiving $500,000 in arbor fees that will replant those trees throughout our community and other areas, preserving Warner Springs' brand of Tree City USA and our arbor canopy.
Because you believe you set a precedent.
Yes, and again, if our residents want to cut down a tree, they have to pay a fee. If other developers want, like Dreamfinders did, they had to pay fee and do some remediation work to offset that. We can't go showing special treatment. We've got to be consistent or the arbor ordinance falls apart and we lose our brand in Winter Springs. I'm proud of our trees. I think it helps make us who we are. And I'd like to continue fighting to protect that. These kinds of agreements or these kinds of exceptions endanger that significantly.
Mayor, thank you for your time.
Yeah, thank you. I appreciate the opportunity to be able to kind of lay it out and for folks to understand. I think that the next commission meeting should probably be a lively one. Thanks. I appreciate it.